Everyone please go. Do not cross this. Okay. You may have to come here. Come from here. Submit. सबके माइक्स पहले ऑन कर दूं?
नहीं
सौरभ सर, सबके माइक्स पहले ऑन कर दूं? सबके माइक्स पहले ऑन कर दूं? अभी नहीं करूँगा।
Digital on bias, so we should maintain right? Cover up.
मेरा ये है, मेरे को चाहिए पर
नहीं नहीं नहीं, तुम्हारे पास कोई फोन है? हाँ ठीक है, हल्का और इधर करो।
भाई अब आ जाएगा वो
हाँ,
आ गया कि
रिस्पॉन्डेंट बाद में पास करते हैं, पटीशन शुरू करा देते हैं, ठीक है ना? तो एक काम करो, All right.
Ma'am? Sir? Please.
The court is now in session.
May I have the honorable bench permission to proceed with the matter? I will seek liberty of the honorable court to address the honorable bench as the lordship in the matter. My lord and my lady, since the present is the set of three cases, one is the special leave petition honorable of the state of Russia, and second is the presidential reference, or is the writ petition from the former chief minister of the state of Telangana. My lord, I shall be assisting you on the bench for in the special petition for the applicant and in the presidential reference for the intervener respondent union government. My lord, as far as the jurisdiction of the case is concerned, the honorable chief the president of Indiana has sought the learned opinion of the honorable court under Article 153(1) of the Constitution of Indiana, and third is the writ petition by the by the chief minister of Russia, challenging the proclamation issued by the president of the Indiana under Article 356 of the Constitution of Indiana. My lord, before I assist on the issues, may I give a short introduction of relevant facts? My lords, on one fateful day, the government of the state of Croatia issued a notification that henceforth no one shall wear hijab in all the educational institutions. Several protests erupted in the state, and in the state legislature there was coalition government. Now there came to be a split between the parties on this point. One party said that the ban is right, and one party said it is wrong. Ultimately, the government broke. The president of Indiana pursuant to that, issued a proclamation under Article 366 of the Constitution of India. And incidentally, the Union Parliament brought an amendment we call the 106th Constitutional Amendment, which in summary provides states a right to secession. My lord, as regards the right under Article 25 and 19 of the Constitution of India, I will be assisting your lordship first in the Article 25. Now, prima facie, Article 25 protects the practices which are essential part of the religion. The proposition which I am going to lay for the lordship, and I will make judgment in that regard also, that the essential religious practice test has been evolved with respect to Article 26. It has no application when Article 25 is invoked in isolation. Because the fundamental difference between Article 26 and Article 25 is that Article 26 talks about right of religion and religious denomination, whereas Article 25 talks about right to conscience. Since conscience includes atheism also, the essential religious practice test cannot be applied to conscience. So the first judgment in this regard, the first authoritative pronouncement of this honorable court is the Shurut case. Now, in that case, the challenge was to the intervention of the Hindu Religious Endowment Board to a religious body. Now, it was contended that it violates Article 26 in as much as it interferes with their right under Article 26 to manage their own religious affairs. My lords may seek the companion page number 97, the judgment is there. And the lordship was considering the purview of Article 26. The lordship said, Article 26, under Article 26, every religious denomination has the right to manage their own affairs which are essential and no outside authority has any role in it. There are two inferences. First, it was said in the context of Article 26, and second, even the practice essential, it is the community who shall decide. Now, the same ratio came to be followed in the state of Ratilal Sanatan Gandhi at page number 94 of the compendium. The lordship said, once the community decides that certain practice is an essential, no outside authority, no secular authority can question its validity. And same ratio in Sardar Vedanath Sahib Safruddin Sahib and Sardar Swarupuddin, which was the appeal from the High Court of Punjab. But the conflict arose from the obiter dictum of the Lordship Justice Gajendra Gadkar in the Dargah Committee case. The judgment is at para 75 of the compendium. The Lordship in the obiter dictum said that even it shall the court who shall decide it, and even application recognize the application of essential religious practice to Article 25. Now, the conflict, please.
When you are referring to Article 25,
Please,
are you referring to Article 25, Clause 1 or Clause 2?
Madam, I am happily submitting under Article 25, Clause 1 of the. Now, the difficulty is that certain coordinate benches and division benches follow the dictum of Shurut Mat and Ratilal Sanatan. Certain coordinate and division benches follow the ratio of the Dargah Committee. This conflict came to be recognized by your lordships in Sabrimala Review as to the scope of application of the essential religious practice test to the Article 25. So my humble proposition is there is no need to delve into the essential religious practice test at all for the simple reason that Article 25, one of the lordship said in the Babri judgment that this is the constitutional code. This is the code, this is the arbiter and guardian of the constitution. This code must desist from ending upon the territory of the role of the religious. So therefore, my humble submission is as to how to decide what is protected under Article 25 of the Constitution. Your Lordship in Shri Lakshmina Jitendra answered this at paragraph at page number 70. My Lord, the humble proposition is as long as the practice does not offend three inhibitions of Article 25, public order, morality, and health, it affords the protection of Article 25 of the Constitution. So, my Lord, if there is no need to go into essential religious practice, I must submit at this juncture, your Lordship with respect to the state of Karnataka, though there came to be a separate verdict, but both the learned judges were of the opinion that there is no need to go into essential religious practice test at all. The Constitution has equipped this honorable court with sufficient tools to adjudicate the present case. Another difficulty which arises in the present case is that the state has put the female students in a very difficult situation. One of the scenario is that now the state is saying, and I must submit that your lordship must decide this legal imbroglio, that the state is contending that surrender your article under Article 21 of dignity, right to expression under Article 25 and 19 in order to access the right to education under Article 21A. My lords, and to assist this, the judgment is at paragraph number 14. Your lordship said there cannot be a watering away of fundamental rights. These, please.
One question.
One.
When we're talking about Article 25, right? So in that, are you aware about the subclause 2? So can you just tell me this subclause 2 in the light of your government issued a notification regarding the wearing of proper uniform, right?
Actually, my question was whether you are referring to Article 25(1) or 25(2).
I will connect both of your lordship's question and answer the question. My lords, the Article 2, if I may read with your lordship's permission, that it says, nothing in this article shall affect the operation of any existing law or prevent the state from making any law, A, regulating or restricting any economic, financial, political or other secular activity which may be associated with religious practice. My lord, when any challenge to a particular provision or restriction by the state is called, then if state claims that particular practice is though associated with the religion, but it is a secular, then the Article 25 clause 2A comes into play. But here we are talking of, here we are concerned with the rights of a particular individual of conscience, right of religion and conscience. So if that satisfies the lordship well.
There's such one thing. Subsection sub-article 1 of Article 25. If you read the language of it, it starts with the word subject. Subject to.
Subject.
What impact would that have with regards to the practical implication of creating a restriction? Because my view is that sub-article 1 of Article 25 is not a substantive provision. It's only a guideline which has been given to the government of India under this Article 25 to formulate a certain process of law for the purposes of practicing a religion.
I may beg to differ with this. So that's what you ultimately decide, that it is indeed a substantive right, but the Constituent Assembly was aware of the diversity and the reform which may need to be introduced in the country. That's why the Constituent Assembly put three inhibitions, and they are sufficient to cater to the needs that subject to public order, morality and health, and to the other provisions of the part, all persons are equally entitled to freedom of conscience and the minor emphasis is laid on the word and the right freely to profess, practice and propagate religion. The provision which says that subject to public order, morality and health, in my humble submission, it is sufficient to cater to the needs of state and society as a matter of.
So let me reformulate my question. My question was that what is the relevance of the use of word subject by the constitutional mandate when in under sub-article 1 of Article 25?
Well, if any issue of public order arises emanating from any religious practice, then this the right must kneel down. This right must kneel down before public order, morality, and health. This is the understanding which I take subject for watching.
Now, just to know, waiting for a moment.
See, if you read 25
Please.
this is another, here the case was that a notification was made banning that. That's right.
Yes, ma'am.
Here, you are trying to make out the case, the state government came with a notification under the Education Act and Authority, where the hijab was banned. Now see, if you say Article 25 clause 2, nothing in this article shall affect the operation of any existing law. Now mark the word, or prevent a state from making any law. A notification is part of law. Regulating or restricting any economic, financial, political, even delete it, or other secular activities. Right? So, in order to ensure that the secular activity were particularly, the government still can make any law. Now, in a secular state like India, if the government comes with a notification banning that, will that fall out of Article 25 or Article 2?
My lord, in my humble submission, the notification does not come under the part of Article 2A for the reason I will say this one. It says the clause A starting regulating or restricting any economic, financial, political. First, there are three: economic, financial, political, or other sector activity. My lord, the hijab is neither associated with economic,
No,
financial.
not on economic, financial, political. I'm only confining to the word other secular activity.
In my humble submission, hijab is emanating from the right to conscience and religion. It is not a secular practice. It is emanating from so hence it does not come into the purview of Article 25A of the Constitution.
All right, you stated about the intent of the framework of the constitution by way of constitutional assembly debate, stating that they were well aware about that. So if you just refer to the explanation to this article, whatever they were clear they have written in that, the wearing and carrying of kirpan shall be deemed to be the included in the provision of Sikh religion. No other thing has been mentioned or 5K, which is possessed by Sikh religion, case, kanda and all. They are all here.
Our explanation one says that wearing and carrying of kirpans shall be deemed to be included in the protection of the Sikh.
That is the intent of the framework of the constitution, which is very clear.
I am answering this. I must put a question to myself only. Now, explanation one doesn't say that turban, but I am wearing a turban. Would your lordship say that leave the courtroom? How can you express your religious expression and in a secular court? The answer is in my humble submission is no, because this is the aspect, this is the positive secularism. The lordship have evolved that to respect the religious without interfering with their religion. So there are lots of religious practices which have not been mentioned in Article 25, but still are just they are protected by the
All right, move on.
Please. My lords, if I may draw your lordship's attention to the notification. The notification specifically targets hijab. My lords, in my humble submission, it smacks of maladroit intention. Had they been bona fide, they would have said that no religious expression is allowed. They said no, hijab is banned. My lords, even your lordship in Ismail, the judgment is at paragraph at page number 77 of the compendium, has read secularism in Article 14. It is the aspect of equality that the state shall not discriminate on the basis of religion. My humble question to myself only is why only hijab? Had the intentions been bona fide, the state would have said that all the religious expressions are banned. They said no, only hijab. Now that is on the face of it is discriminatory. Another aspect is Article 19 aspect. My lords, in National Legal Service Authority versus Union of India, gave authoritative pronouncement that dress is an expression within the meaning of Article 19 of the Constitution. My lords, if at all there is a restriction, the restriction must be proportional. Your lordships in A.S. Puttaswamy settled that while imposing a restriction on a fundamental right, the state should adopt least restrictive approach. Now, my lords, here the principle of reasonable accommodation comes into play. My lords, I want your lordship to take note of the point before I delve into the issue that we do not have any single objection to the uniform. We are merely contending, please allow us to cover our head over the uniform. We are not saying that we are against uniform or we are against equality. We are merely saying that please allow us to wear a uniform. My lord, that even the Lordship Supreme Court rules and Bar Council rule says that even the Chief Justice, that the second Chief Justice of India, Patanjali Shastri, would wear tilak. That is the positive secularism that we have evolved in our country. Now, my lords, there are international judgments. The principle of reasonable accommodation comes from the jurisprudence of South Africa and international judgment. Now there is a Canadian Supreme Court judgment at page number 87, which squarely covers the present case. It may be of great assistance to the court. Alright, in that case,
Page number 87.
87, the highlighted portion.
Then it's okay.
The page number 8. My lords, the kirpan was banned. However, our constitution provides explicit exemption. In their constitution, the Article 25 is almost perimeter, the right to religion. The kirpan was banned. Ultimately, the matter came before the Canadian Supreme Court. Now, the Canadian Supreme Court said that it was a case concerning the school where the just yes, ma'am. At paragraph number 76, the ratio, this is the majority ratio. Religious tolerance is a very important value of Canadian society. If some students consider it unfair that Gurbaat Singh may be in school, while they are not allowed to have knives in their possession, it is incumbent on the school to discharge their obligation to instill in their students this value that is, as I will explain in the next section. My lord,
All right, one more. We're talking about the reasonableness. Reasonableness in such a word, has it been defined anywhere? Or there is some criteria to take what is reasonable and what is not? Who is authorized to do that? We would like to know your opinion on this.
As stated that the Lord CS put us on the made the law very clear on the proportionality. My lord said that the restriction first should be rational. Second, it must be legitimate and must be within the purview of Article 13, the law. And the third is, it should be, the state while imposing it should adopt least restrictive approach, and there should be a direct nexus to the object which it sought to be achieved. Manu, this is the criteria which your lordship laid in the case put us on.
No, just, can I put a question to you?
Manu, please.
Now, Article 13 that defines the law. Now, in case if you say that that has to be reasonably construed, then why Article 25 explanation 1 and 2 have carved out an exception to a particular religious group?
In my humble submission, the explanation which the Constituent Assembly put in the Constitution was somehow political. They know that this is a sharp object, this is a weapon. Now, because the Constituent Assembly did not give the right to weapons, so it may, the situation might have arisen targeting the sex. So the Constituent Assembly deemed appropriate to provide explicit exemption that kirpan, since it is emanating from a religious practice, must be exempted and be allowed under the Constitution. That, in my humble submission, might have been the intention.
No, you mean whenever that explanation 1 and 2 was introduced.
Please, my
Now, that explanation, whenever it was introduced in Article 25, at that particular point of time, this Muslim community, where this customary rights of putting on hijab was prevalent. Now, why didn't the Constitution in its own wisdom incorporated that in an explanation? That permitting of an hijab, why this exception was carved out? Will it not be violative of Article 14?
Because the Constituent Assembly did not see any conflict arising from the hijab. It was, the practice is very innocuous. So, kirpan was a weapon. So, conflict might have arisen. To avoid that conflict, the Constituent Assembly deemed it appropriate to exempt it. But the hijab is a common practice which is prevailing all over the Muslim or practicing society as a matter of. But since it was a sharp object and weapon, so they deemed it appropriate to put an explicit exemption in the However, there are so many practices which are protected by your lordship, but not mentioned in the constitution, but still protected by Article 25 of the constitution.
No, that way, in case if I accept your answer,
Please, my lord.
then I think putting out of hijab will be more difficult than carrying a weapon. Looking into the present scenario where there are so many terrorist activities going on, so that will be more lethal weapon rather somebody covering and camouflaging herself.
Please, sir, my lord's concern is why to be addressed, and I will satisfy your lordship on this aspect. That hijab merely covers the head, like I am covering my head with the turban. It does not put any, it does not bring or invite any security issues. I can cover my head. They also can cover their head. It doesn't cover the face. It merely covers the head and the upper portion of the body. Please, ma'am.
Do you give up the argument where ERP, essential business practice, or you still insist upon it?
My humble submission is that there is no application of essential, in my humble submission, I say it on record, that there is not a single authoritative pronouncement by your lordship, and that's why the matter has been ultimately went to the ninth judgment, that whether in isolation Article 25, whether it is application on Article 25, the matter is pending before the large judgment. So even how the matter will be decided, my lord, if the matter, if the practice does not offend morality, public order and health, it must be protected.
What I want to say, you want to say that essential business practice argument, you are not insisting upon, you are giving up the argument. It is not a part of essential business practice.
My lord, I will, even if your lordship, if at all inclined to apply the essential religious practice on Article 25, I will satisfy your lordship on that aspect too. If, now my lord, but the question is, I will ultimately satisfy on that, but the question before it arises, how to decide the essentiality? Now, in Commissioner of Police versus Acharya Jagdishwaran up to the previous bench of this honorable court that it must be a fundamental to that religion, and changing in that practice must cause changes to fundamental. The whole religion must change. But in Shirur Mat case, that is the 7th constitution, and
My question to you was, are you relying upon ERP argument or not?
My lord, my humble submission is there is no need to delve into essential religious practice test or, but if at all your lordship say that no, there is application, I will satisfy on that aspect too.
This is for you to decide. Are you giving up the argument for ERP, or you want to continue with the argument for ERP for you to decide?
In my humble submission, I am not giving, but if your lordship call upon to satisfy that no, satisfy us on the essential religious practices, I will indeed satisfy.
Just answer me one question. Just tell me whether law should be progressive or not, and especially in a case where a girl child is involved, when she is entering into a college or a school premises, and for her overall development, what should be the law policy?
My lord, my daily, I respect your position for that we have to accept this unfortunate reality of the society, that society is still rigid when it comes to culture. My lord, the omnibus ban on hijab and all the education institutions could be a chilling effect on the right to education. It is the essential, the practice is so embedded in the religion that they will choose to withdraw their girls from the schools and education institutions. And the lordships having Yusuf Shine versus Union of India, all the majority judges were in the policy or the opinion that practice, so it be asymmetrical, the reformative opinion of this, neither of this constitutional court nor the state would engage its practice, as long as it is within the confines of Article 25 of the Constitution.
But we have seen that at times law has reformed the public opinion. That Sati case, if you say so, that law should not be made like this to prevent something which is not impacting to the progress of society. But this is the counter saying that law should be made like the public opinion, the public opinion. At times, public opinion is modified by the framing of laws.
I'm grateful that Dr. Lordship has asked this question. But question arises, and I must pose question to myself only, how this hijab of ban reform the educational rights of a female student? Or it doesn't. In fact, it will
No,
have
no, no, you will not correct in that. If a girl child wants to take education in a particular school, which according to the society or her parents is the best school, and she wants to take education in that particular school, now she is denied the entry for them. So don't you think that the law should be, what he said and what I am saying, that law should be progressive within the four corners of the constitution, how it is to be decided. If you were the judge, what will you do?
My lord, in my humble opinion, if now a girl comes wearing hijab, she wanted to take education in a particular school, not only because of her right to religious expression. Now they are saying you give away your right to religious expression, and in order to get education.
Don't you think there is a conflict between education and religion at that time?
Perhaps that is the right query, which is a more question for your lordship consideration, is that a conflict of fundamental rights. But one side is the right of education and religious expression. Your lordship at page number 74 said that there cannot be watering of fundamental rights. All the fundamental rights must be given harmonious conception.
So
If-
which will precede, the right of religion? Or
Right
right
of
of education?
that in my humble submission, that is the option choice. There is no choice at all.
Right of religion, can it be an absolute under the constitution?
Not in any manner it can be absolute. There are inhibitions in the article itself, but it cannot be put against the right to education. Both the rights must be given harmonious interpretation. If the girl wants to wants to take education in a particular institution, she should not be denied merely because she is covering the head. My lord, that restriction is itself irrational in my humble submission.
Let's go beyond this, that this girl, among thousands of students, she wrote an examination, entered an examination, and then she was selected for this particular place, the school or the college. And just because of this small thing, she is denied entry. How do you balance it? See, we all know that this matter is pending before the Supreme Court and two judges have given different verdicts. And it is still not yet decided. So, we just want to know from you, what is your view?
My humble submission is that
All right, on last question, before this court allow you to move further. It seems that the whole thing is revolving around the concept of reasonableness. It is there, if it is reasonable, it will be denied if it is not reasonable. So this court has given the authority long back in the case of Arunachal Nadar case. Are you aware about that?
My lord, right now I'm not aware of the fact of it, but if it assists your lordship, I will come up with if it helps the adjudication of the federal case,
I'm taking the clue from Professor.
But your lordship may put the ultimate question. What is the question?
So the court has already given the guidance what the reasonableness should be, right? Okay.
My lord, whatever has been laid down in the case referred by my lords, it must be in consonance with the judgment of K.S. Puttaswamy. Because K.S. Puttaswamy just gleaned out all the law on the reasonableness. So the criteria which your lordships lay down, that it must be rational and it must be legitimate and come to
Please. Move on.
So my
Now,
lord,
one thing, what if mind is so unreasonable, then why it is so that many developed countries, they have completely banned it?
my lords, because the secularism which we have evolved and adopted is different from that the so-called developed countries, my lords. They have the
The constitution itself might be borrowed from developed countries.
Please, my lord, may
Even constitution itself, and many things that have been borrowed from the constitution of many
but
countries.
what constitution says, it is this court interpret. This court has interpreted that constitution is intending that there should be a positive secularism. Now the positive secularism means I wear uniform, but I am wearing turban. That is the aspect of positive secularism. I will move forward to the second convention. We attack the constitutional 106 constitutional amendment as it violates the basic structure of the constitution. My prime most proposition in this regard is that constitution cannot be used to withdraw its allegiance from the constitution itself. Now the constitutional amendment says, now the parliament has made the constitution say that the constitution is now saying that you withdraw your allegiance from me. But that is self-destructible to the constitution. Constitution cannot say you can withdraw your allegiance to me. That is destructible. And it conforms to the ratio of the case one and Bharti case. The Lordship, I will quote the judgment of the Lordship Justice Grover and Heller. They said that constitution cannot be legally used to destroy the constitution itself. So my lord, the amendment says that now constitution is saying that you withdraw your allegiance from the constitution is destructible to the constitution. And this court, being the sentinel and guardian of the constitution, and the I will submit to judgment that the iron hand of your lordship must strike blow on such action. This is self-destructible to the constitution. The constitution cannot say you withdraw your allegiance from the constitution. My lord, second is that the amendment is hit by the principle of federalism. My lord, the federalism, as in Keshwananda Bharti, in S.R. Mumbai, have very succinctly expounded the concept of federalism.
One point. Your government is not party to the UDHR, international civil and political rights conventions. If yes, what is the validity of it?
Now, indeed, the Indiana is one of the founding members of the United Nations, and it recognizes the right to self-determination. And I must clarify that right to self-determination is not synonymous with secession. First. Now, the second is, my lord, the Internet Article 51C mandates state to respect international treaties and obligations. But my lord, the law is settled. The international law cannot dictate the constitution. The constitution, when there is a conflict between the domestic laws and the international laws, the domestic law will prevail. Now the constitution, as the interpreted by your lordship, it says that it cannot be used to.
So you mean to say whatever is comfortable to you, you will accept that out of the entire document, irrespective of the fact that you are the signing authority in that.
That is not my humble submission. My humble submission is we have to respect the international obligation. The parliament has to respect the international conventions and laws, the executive, but the supremacy is of the constitution. But once the moment constitution says the contrary, it has to prevail. That is the law which your lordship laid in the case of parliament.
See, council, this court want to know
Please.
if it is against the provision of the constitution, what made us to sign the convention?
It is not that self-determination is against the constitution. It is the secession which is against the constitution. Now, they are the government. I want the lordship that it must be the respondent side must explain as to what is the concept of self-determination. If self-determination to be deciding the authority govern, then we have the universal adult principle. The people decide the government, but the constitution is supreme. It is inviolable.
You want to say that self-determination means a type of democracy. Democracy is also self-determination, meaning that you elect your own government. This that. But come to another point. At the same time, you are also advocating that the state should be given the right to secede. At the same, once this constitutional amendment is declared unconstitutional, how you can then ponder upon about issue number 4?
I must clarify on this aspect that
No, what I am saying is you are arguing against you.
I will answer. But I must give a clarification that in our petition we are against the right to secession to the state of Croatia. Please refer to our session of Croatia. So we, in my humble submission, we are not contradictory. We are saying that constitutional amendment is invalid which provides secession, and so there should not be any right of secession to the state of Croatia. If that satisfies
What I'm saying is, you are a petitioner on all the four issues. All the four issues. There are four issues before this court. The fourth issue that you are arguing about, that the state should give a right to secede from the union. Once this constitutional amendment is struck down by this court, how you will press upon issue number 4?
My lord, we are not pressing upon issue number 4 in a affirmative. We are saying that no right should be given. Please, my lord, may refer to our prayer. We are saying state of Pelosia should not be given the right to secede from the union. My lord,
Therefore, sixth amendment is unconstitutional.
in our humble submission. Well, that is the aspect. Now it hits at the concept of federalism. My lords are aware in Jindal statement is limited to 9 judge bench of constitution bench and the SR Mumbai. It was made clear that there is a slight contrast with the federalism in United States of America or
concluding within 1 minute.
Please, madam. First, the concluding my submission is that it's at federalism because now, madam, I test which I lay before your lordship is that in order to a state to have a right to secede, it must have its sovereign identity before its incorporation to the union, as at parties like the US. But here is not the case. As your lordship
In that case, the only question is, in your opinion, you are federal or unitary?
We are not neither a strictly federal or unitary. We are quasi-federal, as your lordship recognized in state of Rajasthan versus Union of India. That there is a division of power with a strong bias towards center.
No, this would expect that you should go beyond the Professor Vyare. There are some other opinions, and this court also has given opinion on this during correspondence party, right?
But the law has been settled by your lordships in SR Mumbai or in state of Rajasthan that the India is a quasi-federal and the Constituent Assembly was aware of these separatist tendencies and the partition. So it made that strong bias toward the center. So that things that unfortunate things can be avoided. So my lord, in my humble submission, the last in one line I submit that the preamble which says that unity and integrity of India, my lord, it directly hits at unity and integrity of India. Your lordship in Derubai, unit, though that preamble is not a part of the Constitution of India, but the majority judges in Keshavan Bharti overruled this proposition. They said no preamble is a part of the Constitution of India, and the lordship in SR Mumbai said that the components of preamble tells what constitutes as basic structure, though not exhaustively. Now the unity and integrity constitutes as basic structure, and the amendment directly hits that federalism. And in my humble submission, it should be struck down as unconstitutional. I humbly ask.
The council seeks permission to approve the text.
Greetings to the Honorable Bench. I will be representing the respondent in the pertinent case, and I will be assisting the Honorable Court in contention number 3 and contention number 4. If the bench is well seated, I request to move to contention number 3.
Hold on. Petitioner, second, Mr. Reynolds.
Your
Lordship, you are the
Okay.
they are the petitioner.
All right.
Much obliged. Your Honor, contention number 3 is that the imposition of president rule in the state of Pelosia is constitutionally invalid. Your Honor, before getting into the arguments, the council seeks permission to bring forth the intention of the Constituent Assembly, which was present at the time of drafting this article. Your Honor, when Article 356 was being drafted, there was a question which came before the Constituent Assembly that if this article makes it to the Constitution, it would transform the Union of India into a centralized form of government. And to answer this, B.R. Ambedkar expressed his view that this article is in no way in contravention to the federal structure of India. And the reason the reason he supplied to this argument was that this right, the power which is given under Article 356, should be judiciously used. It should be used as a last resort, and it should not be applied in every other case. Your Honor, dear Ambedkar was of the view that every interpretation which is to be given to Article 356 should be given in consonance with the federal structure. And this view was also upheld in the case of S.R. Bommai versus Union of India.
One question, before you move on.
Please, yeah.
Now, this interpretation of 356, this court will die that you come up under the backdrop of Article 355.
Much obliged. Your Honor, Article 355 of the Indian Constitution states that it is the duty of the central government to protect the state government from any external or internal disturbances. Now, Your Honor, Article 350, when read with Article 355, Article 356 would also prove to be a duty or an obligation which is obligated on the president to protect the states. Your Honor, the council humbly submits that as it is a duty, the scrutiny which is associated is more in degree as would be associated with the power. And this duty should be judiciously exercised wherever it is required, and this duty should not be exploited due to modified reasons.
Just tell me one thing. The
Yeah.
Article 355, because it is to be read in consonance with Article 356.
Yeah.
Whether they are in contradiction to one another or they have got a different object to be achieved.
Your Honor, this question came in front of the bench in S.R. Bommai, and the bench of S.R. Bommai was of the opinion that these are not in contradiction. The Article 355 is in consonance with Article 356, and they both are in consonance with the federal structure of the Constitution, and they should be read together so as to be interpreted according to the concept of federalism and to protect the dignity and the functions of the state.
Look, I read the subject head of the two articles. They are entirely different. My view is that these two articles have got a different objective to be achieved.
Your Honor,
See Article 355.
Your Honor, I should tell you.
Yes.
It shall be the duty of the Union to protect every state against external aggression and internal disturbance, and to ensure.
So this is an article which entails the government's responsibility to maintain a certain object which is contemplated under Article 355.
Yeah.
Now, how would you say that it goes in harmony with the objectives contained under Article 356?
Yeah. Your Honor, both of these articles are in consonance to each other. It is just the scope of these articles that is different. Your Honor, Article 355 imposes a duty on the Union to see that constitutional provisions are being obeyed by the state. Your Honor, Article 356 states that if the Union is of the opinion that constitutional provisions are not being followed, then they can impose president. Your Honor, Article 355 merely states the intention, and Article 356 states the action which this Union has to take if Article 355 is to be complied.
There is another question I want to ask you related to this only.
Yeah.
Where 355 says that the Union will take care of two things: external aggression in the state and internal disturbance.
Yeah.
So, what do you understand by that?
Yeah. Your Honor, external aggression would mean in this context that if the problem which is being created originates externally and not within the state. It might be an attack from a different state or different country. But Your Honor, internal disturbances would mean the disturbances which have arisen within the state, as in the present case. The protest which is being done by they are the people, they are the resident of that particular state. Your Honor, according to counsel, that is the difference, that is the intention which was.
Now, in the present case, government has lost the measure.
Yeah.
So there was no clear option to form a government. So it is not a background of the constitutional machinery to impose the presidential rule under Article 356.
Yeah. Your Honor, the council agrees that there was a breakdown of coalition government, but the council humbly submit that president rule should have been imposed and it has to be imposed as a last resort. Your Honor, there should have been a flow test. The provision of flow test has been held mandatory. Your Honor, when the function of the governor was came in question in Vijayananda Patnaik versus Union of India. Your Honor, in that it was held that because Article 356 has been taken from Government of India Act 1935, which in turn was taken from the British Constitution. Therefore, to interpret Article 356, we have to take help from British Convention. And Your Honor, it is a settled non-British convention that before imposing president rule, flow test need to happen. Your Honor, in the present case, there was.
But was there any party who has claimed majority?
Your Honor. Your Honor.
As per the statements or as per the facts available, there was no party which claimed the majority in the house. So in such a case, till somebody come up with a case that he is having the majority in the floor, how you can say that the imposition of president rule was wrong?
Your Honor. Your Honor, the Council humbly submit that it is the duty of the governor to ensure that the state works within the framework of the constitution. And in regard to this, it is the duty of the governor to ensure that there is a state legislation. And if to perform this duty, the governor is to send an invitation to the political parties, which according to him demands majority in the house. But if according to him there is no such political party which commands authority, he should ask the members to vote and to choose their leader.
All right, Mr. Procedure.
Yeah.
Just you see the language of the article.
Yeah.
The President of India is satisfied
Yeah.
on the report of the governor of the state or otherwise.
Yeah.
The otherwise one need a lot of interpretation.
Yeah.
So it is covered with that.
Much obliged.
If governor is duty bound, what about the nation? The President of India?
Yeah. Your Honor, the Council humbly submits that flow test should have been done and it is one of the most important ingredients, and all the other remedies should have been exhausted before the imposition of president rule, and the same is held in SR only. But to satisfy the query of Your Honor on the word otherwise, Your Honor, the otherwise word as it comes in Article 356 should not be given a wide import. It should be restricted, Your Honor. The word satisfaction of the president as it arises in Article 356, the satisfaction of the president should be based on an objective material, which can be inferred that there is a breakdown of constitutional machinery. Your Honor, the satisfaction of the president is not equal to his personal whims and fancies, and he cannot just impose president rule on such trifle and such small problems as they come in the state. Your Honor, also in regard to the breakdown of constitutional machinery, the council humbly submits that there was just a mere protest without any damage to the public property or to the private property, and this has been very well mentioned in the Moot law that there was no damage to public property or to private property.
All right, move on.
Your Honor, and thus this, Your Honor, I should live on this breakdown of constitutional machinery. Your Honor, and this protest can in no further stretch of imagination be taken as a breakdown of constitutional machinery. Your Honor, in Thiru K. and Rajagopal versus Thiru M. Karunanidhi, even the dissolution of the legislature was not held as a valid ground for breakdown of constitutional machinery. Then how can just a breakdown of coalition government be taken as a valid ground? Your Honor, on page, if you refer to page 60 of the compendium, on page 60 of the compendium, there is an excerpt from the case of SR Bome, and it states that there should be measures should be taken and flow test should be done. But if in any particular case the circumstances are such that flow test could not be done, then it is the duty of the governor to give to the president in writing the cause why flow test could not have been done, and all the measures should be exhausted before president rule is imposed. Your Honor, the council humbly submits that this is an arbitrary use of power, and there is a malignant intention before this imposition of President Wu. Your Honor, it is the first time that a different political party from ISP made it to the state legislature. And Your Honor, this is the same government which holds authority, which has the government at the central level. Your Honor, this case was dealt in SR Bome, and it was held that just because when President rule is imposed to do away with the politics.
As per the proposition, the party supporting your government has already withdrawn the support. And situation in the state is worsening day by day because of the agitation. So how you say that it is necessary to have a floor test when they have already withdrawn? Already withdrawn this, they might have given affidavit to the honorable governor of the state.
Your Honor, the Council humbly submits that India being a democratic nation, there are a lot of political parties, and in so much political parties, these small political disturbances are normal. There might be a case IJP would not be able to form a government with ISP due to political disturbance, but IJP might form government with some other political parties. It is not just that ISP and IJP are wrong.
Do you know the practices, British practices which you are quoting? That is not even given the last resort to form a government with the collaboration of such parties, those who are behind to form government, only for them. It's the not only last resort, it should be avoided, that practice which you have quoted shows that. What do you say about that?
Your Honor, India is a democratic country, and if measures are to be taken to control the agitation, then parties can come together, and if the activity is met, then there is the council humbly submit that there is no restriction on with whom the party wants to come into coalition.
In other words, you want to say that the powers given under Article 356 is not an absolute power.
Yes, Your Honor.
It has to be scrutinized by the president or the governor based upon the material which is placed before them to satisfy. The use of word satisfy is that there has to be a material before the court,
Yes,
before
sir.
the governor or the president.
Yes, Your Honor.
That is what you want to add.
Yes, Your Honor.
Now, one more thing. This question which is posing before this bench is on the reference of presidential reference, isn't it? So whether this court is obliged to answer this presidential reference?
No, Your Honor.
Because if you go by fact, the government which was formed in the state belongs to a particular party, IJP, and the central government was also of the same party, IJP. When this presidential rule is imposed, which party lost the power? IJP. And IJP have not come before this court seeking any grievance from the presidential proclamation of imposition of the emergency.
Yes, Your Honor.
So how this court should, why this court should give an opinion on a redundant issue?
Much obliged, Your Honor. Your Honor, the council humbly submits that this case has not come under the presidential reference. There is a writ petition which has been given by the ex-CM of the party, and this is the petition and not a presidential reference. The presidential reference is with regard to contention number 2, whether article 106 or 102, right? Much obliged, Your Honor. If Your Honors are convinced, the council seeks permission to move forward from contention number 4. Your Honor, the contention number 4 is that the state of Kalossia cannot be given the right to secede from the Union. Your Honor, as it has been very well established by my co-counsel that the 106th Amendment is constitutionally invalid, and if that view is upheld by the learned bench, then the question whether the right can be given to Kalossia or not does not arise. But to still appease the query and to satisfy the bench, the co-counsel would deal with the contention. Your Honor, Kalossia is a very peculiar state. It is the only state which practices the religion Draconism. The majority of the people belonging from Draconism religion are present in Kalossia, and they are not found in other parts of the Union very prevalent. Your Honor, the people of Kalossia are only demanding to secede from the Union on the basis of their religious differences. Your Honor, if Croatia is allowed to secede from the Union based on religious differences, this would hit the principle of unity in diversity, which is practiced, professed, and propagated by the Union of India. Your Honor, if Croatia is allowed to secede from the Union, this would also be hit by the concept of federalism as it has been very well established by the co-council. Your Honor, if Croatia is allowed to secede, it could also be hit by the concept of secularism. Your Honor, Croatia is one of the most important states in the Union of India. More than 10% of the GDP of the country comes from the state of Croatia. Your Honor, if Croatia is to secede, it would not only impact the people of Croatia, it would impact the whole country of India. Your Honor, and thus this against the principle of secularism.
All right, Council. One question.
Your Honor, the Council wants to clarify, it is not against the concept of secularism, the Council intended to say socialism.
All right. Now, as you said that in this case, a state cannot be allowed to secede from the country. Okay,
Yeah.
on so many grounds.
Yeah.
So, as per this amendment, there are two things. One is referendum.
Yeah.
If it goes beyond that, and you are talking about a state which give maximum GDP to the Union of India.
Yeah.
So, if you are
Your Honor, this provision is in itself flawed, arbitrary, and against the very much principles of equality of the Constitution. Arbitrary and against the very much principles of equality of the Constitution.
Read the second part of it also.
Your Honor, of second part.
The same, we are saying 20%.
20%. Yes, Your Honor.
second part of the amendment.
Yes, Your Honor. Your Honor, the second part states that if 50% of the people vote in favor of secession, then the state would secede. Your Honor, even this is flawed that how can 50% of the people, by just simple majority, can decide the fate of
This is conjunctive, not restrictive, because the word is and.
Your Honor, the referendum would be valid if 20% of the people vote in favor of referendum, the referendum should be done. And once the referendum is done, in the referendum, if 50% of the people state that yes, we want to secede, then they would secede. Your Honor, both of these provisions are flawed because how can a portion of the population be granted the power to decide the fate of so many generations to come? Your Honor, while I say this, I would like to bring forth the condition of India and Pakistan. Your Honor, the condition of India and Pakistan at the time of partition seems to be very similar to the facts of the present days. Your Honor, India and Pakistan, the most deciding factor between the partition was also religious differences. And Your Honor, the condition which is prevalent in India and Pakistan today is very dire. And thus the Council humbly submits that if the state of Croatia is to secede from the Union of India based on religious differences, it would not be in the benefit of the people, and other measures need to be done as secession is never the answer. Your Honor, I also pose a question to myself that how can an expressed provision of our constitution, that is the protection of unity and integrity, kneel down before an unexpressed provision of our constitution, which as the respondent demand, that is self-determination. Your Honor, if Your Honors are convinced with the arguments, the Council seeks permission to move the bill.
come for the prayer.
Yeah. In the light of the facts of the case, issues raised, arguments advanced, and authorities cited, the Council on behalf of the petitioner plead before the Honorable Court to kindly adjudge and declare that that the notification banning hijab is constitutional and does not violate Article 19 Clause 1 Subclause A and Article 25 of the Constitution of Indiana.
That is the one. You are for, what of your appeal to the appellate, the Article 136 petition.
Yes, Your Honor.
Which has challenged the judgment of the High Court, where it was held valid.
Notification was there.
Yes, you are now saying.
No,
just
no, Your Honor, we contend that the notification is unconstitutional.
No, but you have just said that it is.
It's a contradictory argument.
Yeah, you have just said that it does not violate Article 19, 1 and 25, which is just, the contrary to the argument your colleague has just made. You are from the appellate board of the understand, right?
Your Honor.
And you are from the appellate that you are not supporting the current High Court judgment, rather you are trying the judgment should be set aside. So you are against the notification, but you have just made a prayer for the notification.
Your Honor, the council likes to manage it, must be about that, Your Honor. May I proceed, Your Honor? That the 106th Constitutional Amendment is constitutionally invalid, and the imposition of President rule in the state of Colombia is invalid. That the state of Colombia cannot be given right to secede and or pass any other order or grant such relief as the bench will deem fit in the best interest of justice, equity, and good conscience. And for this act of kindness, the council on behalf of the petitioner, as in duty bound, shall forever pay. It was an honor to be before you.
The council seeks permission to approach the dais.
You are against the motion.
Yes. If it may please the honorable court, the council would like to address the bench collectively to your lordships and individual relation. This is council number 1, appearing on behalf of the respondents in the instant matter of Alisa Firdaus Fernandez versus State of Colombia, Indiana Young Lawyers Association versus Union of Indiana, and Akhanan Tripathi versus the Union of Indiana. All the 3 petitions have been heard by the honorable bench for a collective hearing. Would your lordships appreciate a brief perusal of the facts at hand?
Facts are not correct, come on.
Much appreciated. Your lordships, the council seeks permission to move on to the statement of jurisdiction.
Yes.
Your lordships, 3 separate petitions dealing with Article 136, Article 143, and Article 32 of the Constitution of Indiana has been filed, which has been combined for a collective hearing under your lordships. Your lordships, in this instant case, there are 4 issues, out of which the first 2 dealing with the restriction upon a fundamental rights and challenge to the constitutional validity of the 106 Constitution Amendment Act would be dealt by me, and I will be taking 22 minutes of the court's time, while my co-counsel will be dealing with the remaining 2 issues and will be taking 20 minutes of the court's time.
You are dealing with issue number.
1 and 2. Your lordships, the first issue deals with the petition filed by the lawyer petitioners claiming alleged fundamental rights infringement under Article 19, Clause 1, Subclause A, and Article 25, Clause 1 of the Constitution of India. For the convenience of the court, I will be dealing with each of the provisions separately by way of a two-fold argument. The council seeks permission to move on to the argument. Much obliged. Your lordship, it is humbly submitted before you that the restriction imposed on the fundamental rights was reasonable in light of the reasonable restrictions imposed under Article 19, Clause 2 of the Constitution of India. If your lordship can please refer to the case of A.K. Gopalan versus State of Madras, given on page 17 of the Moot submission. In that case, the Honorable Supreme Court had held that it becomes crucial at times to restrict the fundamental rights, as under certain circumstances, individual liberty can be subordinated to the other larger interests of the society at large.
One question, See, the object is to provide the education. How does it matter if someone enters without headgear or with headgear? Number 1. Number 2, how can it be said it is reasonable restrictions? Well, you are saying that this is reasonable restrictions. Now, putting a hijab, if the amount and the object is to impart education, if somebody doesn't put the hijab, so do you think that he or she is to be debarred from the education. So how is it reasonable restrictions?
And I will just add one more thing to what Mr. Upadhyay and Mr. Upadhyay said, that how and who decides the reasonable restriction and what are the parameters of it, in your words?
Much clarified question. Your Lordship's answering the first question at hand. The matter of the fact is that schools, particularly educational institutions, they have to maintain a parity among all the students considering the uniform. Uniform forms an integral part and parcel of these educational institutions, as is also given in international case, which I would refer to Employment Division versus Smith. In that case, the court had held that if a uniform is religion neutral and universally applicable to all the students inside the classroom, it cannot be felt to be discriminative in any way. To maintain the decorum and to maintain the parity in the uniforms prescribed, the schools have to make rules that the students adhere to these educational institutions and these rules prescribed.
So in that eventually, whether this restriction will not be monitored to Article 21.
Actual education. Your Lordship's the matter of the fact is that this will not be violative of Article 21 considering that Article 21 also has certain restrictions under it. If you talk about right to privacy, it has restrictions under it. Right to
Article
education.
21 doesn't have any restrictions, but after Article 19 has restrictions.
Article 21 under right to privacy has restrictions, not under right to privacy.
So how can there be a deprivation of an individual to have education merely because of the fact that the uniformity of the uniform, which is, you say that is of an importance?
Your Lordship's the matter of the fact is here that even the educational institutions as a group also have the right to manage their own affairs and to administer their own affairs according to their own rules. And this also is in line with the fact that we have to maintain a consistency among all the students in these educational institutions to be abiding by, the children should be abiding by all these rules. The fact that it would not be based upon intellectual differentia if there have been different rules applicable for the ones who wear hijab or the ones who do not wear hijab. Another important factor in this sense is that in this particular case, under para 34 of the Moot proposition, it is specifically mentioned that it is not particularly hijab that is banned, but any uniform that is not proper and not in accordance to the education institution's rules, that collectively is banned. So it could be either hijab or any other religious practice.
Can you read that particular provision by which this has been banned? The specific provision. If it cannot be unreasonable for the Sikhs, and there is a carve-out exception in the constitution, how can it be unreasonable for someone who is like that? So and how can you say that, a infirmity in the universe will affect, the whole object of the educations? I am really failing to understand it. Read the particular provision. In fact, what has been banned? Only hijab or many other things also?
Your Lordships were provided with the Moot proposition and not with the section 123, but the fact is that if you could Lordships could refer to the para number 31 of the Moot proposition.
Yes.
Your Lordships, under third last line, it says that under section 133, clause 2 of the Karnataka Education Act, that is the Kaloshi Education Act, stating that no student who is wearing a hijab or is not in proper uniform shall be allowed to attend the classes either in schools or in colleges, irrespective whether it is a governmental institution or a private institution. Meaning that the term proper uniform has a wider connotation, which would also include other religious practices and other practices that are not essentially in line with the rules of the education institution.
The fact of the court case is not that the girl was not in proper uniform. She was in a proper uniform prescribed. Only distinction was that besides that she was also wearing a headgear. Correct? That is the only distinction. So that's a the constitution itself carves out an exception for the sex. How can it be unreasonable for one and reasonable for other? What is the reasonable restriction? That is the scope of that which ma'am was asking.
Yes, sir.
Go, please explain that.
Yes, sir.
I will give you another example, which is whether sex or whether wearing hijab. For example, I go to a school and because I have a big eyesight, I wear the specs and I use some funky, specs. Will it be covered under that restriction? So then if you see the articles which we are talking about, I am wearing a proper uniform. Above that, if I wear a headgear, how is it disturbing? How can you say where is that thin line which clarifies that you are not obeying point number 1, 2, 3 as per the guidelines given. So that, how do you define that reasonable restriction and what is the test for?
You are not just by the virtue of the judgment given in Om Kumar versus Unimapriya, the rational nexus test was used, which basically means that any restriction on our fundamental rights has to first be tested on the angle of proportionality, as well as the fact that there has to be a rational relationship between the objects of the PhD and the restriction imposed. Using that premise and test this particular scenario, what we can see is that the restriction was imposed to impart discipline, decorum, as well as to maintain a particular kind of parity of uniforms among all the students.
Leave aside discipline and all. So you talk about the other.
The object is the
Wearing a
education.
hijab is not, stopping anybody's discipline.
The object is the education. Rational nexus is with the imparting education, right? And why that particular, headgear and hijab is being singled out? There may be many students instead of hijab, he may like to wear a cap, or he may like to wear many other things on the head, as per their own faith and conscience. But you are also singling out a hijab, the word is hijab, not other headgear.
You can just, what can be a hijab or take a synonymous of that. I want to wear a scarf. For example, in the Kashmiri girls, they wear a scarf. You will call that also a hijab. So we are giving just a connotation to that. How do you differentiate? We want to have your views on it.
Because we do not find any reasonable nexus, that is the objective to say that.
We understand it's a difficult case for you, but this is how, your arguing skills are.
Yes, much better the question. Your logics, the matter of the fashion question here is that even if the wearing of hijab particularly is associated with a religion, the fact that any other religion will now next come up and use their essential practices or all their integral practices to come up with as an excuse for saying that this is an essential practice of the religion and henceforth we can use that practice in these educational institutions. Seeing these institutions and their major roles to impart discipline as well as to impart education particularly, these religious beliefs cannot be said to be claimed as a right to be practiced inside these educational institutions, as it's also laid under the Honorable.
1 minute, 1 minute. I think you are answering, but not the exact thing. Thing is that you have to establish the rationality, all right, between the notification and banning of hijab. Come on the point.
Your Lordships, there is a rational nexus considering that schools are considered as an integral part of a children's lifestyle, and the fact that these schools are known because of the uniforms. And if a student is wearing something that is additional to the uniform, that will create a sense of lack of consistency.
I will give you example of many schools where there is no uniform. There are many schools in India also, live abroad, but in India also there is no uniform restrictions. How will you justify that?
Your Lordships, it depends upon the education institutions and their own rules if they want to devise if they want to prescribe a particular uniform in the schools or not. But this act singles out the fact that educational institutions should not be a place where religion should be expressed in such a form that it creates any kind of indecency or immorality. Today it is hijab, tomorrow it could be any other practice that they feel it is an essential part of the religion.
No, that is
And
true.
not only
Government is already around.
That is true. I have to just, you have been conceiving something.
Can it is an executive instructions or notification? Is it executive instructions and notifications that banning hijab or it is under some kind of law?
banning of hijab.
Yes.
Notifications.
Just a notification.
Is it executive instructions or administrative instruction, no, or it is?
It is put by the state government under section 133 clause 2 of the Commercial Education Act that any education institution should have they basically would have to come up with the rules and wearing of hijab or any other kind of uniform that's not proper to the students will not the students will not be able to follow.
Now, in this notification in the constitution, if you read it in consonance to Article 14, 21 and 21A, so you are creating a clear demarcation line. That those who are putting on hijab, they will be restricted to take an education. Is it not audited of the constitution?
Just the fact is that since every right, even the right under Article 19 is subject to reasonable restrictions. Under Article 25 as well, the opening was specifically mentioned subject to public order, morality, health, and other parts of the Constitution, other parts of the Part 3 of the Constitution. Meaning thereby that these rights are not absolute in nature, and becomes the duty of the state to impart these rights in such a manner so that there is an rational nexus, particularly, and there is a restrictive nature. The rights are already restrictive nature and are not to be exercised absolutely even inside educational institutions or outside. Considering that in point, the state government put forth a notification that created a sense of consistency inside the schools, and also the fact that there has to be a balance between the educational right, the educational institutions and their right to manage their affairs against the individual right of one person to express their beliefs in one particular aspect of their lives, that is inside the educational institutions.
But you know, I have a difficulty in understanding this, that you are saying discipline to be maintained. This is at the school level. Then what about the college people? The college students are allowed to wear, there was cases where the girls were not allowed to wear jeans and colored clothes. That is everywhere it is allowed. So when you are at a higher pedestal, when you are going to the college, the technical education or legal education, whatever, like in our institution, at least in law colleges, we are said that on these particular days you have to wear black and white or black coat. But otherwise, you see in any university, people are wearing colored clothes. So how do you stop that? You still justify that the notification is correct, then you have to give us reasons. 1, 2, 3.
There has to be a justification for that.
Keeping that in all those circumstances, the objective is to impart education. How the objective is getting affected? Education you will get whether we are hijab, don't wear the hijab.
Your Lordships, the fact is that
I will help you with some other things also. I will just tell you that imparting education is not a, my dress is not going to. Yes, if I'm taking some drugs or I'm under influence of liquor, I'm not allowed, you are not allowed to enter into the college or the school. So, you know,
Let's
just
Move
these
on.
are the only questions now you can answer.
You answer too many questions at once.
Your Lordships, the fact is that the Moot provision specifically states that hijab will not be allowed or proper uniform inside the schools as well as in the colleges per se. So there is no distinction between schools and colleges being made. Also, if hijab is allowed, there will be an outward and visible expression of their religion and their religious beliefs inside these educational institutions. And again, the council like to humbly submit that since we want to maintain a parity of uniforms and a sense of consistency between all the students.
All right, 1 minute. So this statement, can it be interpreted in the light of Article 25? What it says? Adding itself.
Yes. Article 25 under its ambit also covers the essential religious test, meaning that if any practice has to be termed as an essential practice,
No, just
that is only
speak
when
out the
it's
heading of the article. Heading, just heading.
You see the top.
subject to.
That will suffice.
The heading, it says freedom of conscience and free professional practice and propagation of religion. The opening words, however, says that subject to public order, morality and health and other parts of the provision of Part 3, restrictions can be imposed.
So where these elements are being satisfied when you propagate by virtue of putting on hijab by the notification which is subject to hijab.
In Lordships, the outward expression of one's religious beliefs in a country wherein Traikism specifically is the minority religion, where Indiana has a maximum population of Hinduism, while Traikism is a minority population. In the state of Croatia, however, it is the opposite. The Traikism population is the highest population in the state. So the matter of the fact is that to prevent any kind of disturbance inside these education institutions, that could be public disturbance, that could be an effect to morality, that could be an effect to consistency even. So to stop that, hijab is one such method to stop it. The wider connotation of proper uniform covers all such aspects that could be even harmful to the society. So hijab is just one such aspect that covers the restrictions.
All right, move on. We understand that it is very, very difficult for the respondent to establish, but even this court expects something more from the government side.
The council.
You have to argue something against your conscience.
This is the job of a counsel. You have to argue for protecting your client's case. Sometimes you have to just put your own opinion behind.
Your Lordships, moving on to the next thing of the argument, it is stated that in the case of Tilket Sri Govindaji Maharaj was the state of Rajasthan, the essential, it was.
What is the second point? Yes, what are the avenues? Now this data portion is gone.
The Article 19 one is gone, now it's Article 25 of the Constitution, and the validity is there.
It's only second subject.
Yes. So, second contention of the Constitution.
Hey, it is passed now, come on the.
Go to issue number 2.
Okay,
The constitutional amendment.
yes. Your Lordship, if I have the permission, I will try to do the issue. Yes, Your Lordship. The second issue, Your Lordship, deals with the challenge to the 106 Constitutional Amendment Act that grants the states the right to secede from the Union of India. Your Lordships, under Article 3A of the Constitutional Amendment Act, the states have the right given to secede from the Union of India. Your Lordships, in the case of state of Kerala and others versus People's Union for Civil Liberties, it was stated by the Honorable Supreme Court that groups who are in minority in the country and who have suffered historical oppression and discrimination have a right to self-determination. Your Lordships, a secession for social, political, and cultural justice can be validated on the grounds of right to livelihood and to achieve a moral virtue of life. Your Lordship's liberation of Bangladesh, per se, as an example, could be seen as a right action to maintaining political stability in the state, as well as meeting social and cultural aspirations of the people in the state. It is humbly submitted before your Lordships that even though Article 1 of the Constitution of Indiana grants to Indiana the status of a unitary state, yet in terms of its structure, Indiana is always inclined towards being federal in its nature.
Just one question. You're talking about Article 1. Before you move further, just differentiate between Union of States and Federation of States. And also, this court would like from you, under what background this Union of States word was adopted by the framework of our Constitution.
Your Lordship, Union of States means that the states in that particular country, they have come together, they have been formed as a union. Through the instrument of accession, the Union of States was formed. Every state was given the chance to sign the instrument of accession at the time of the independence. While a federation of states, like in USA, what we can see, the states came together to form a federation.
By way of?
By way of coming together, federation.
By way of? Simply they have stand on road and stated that we are together.
By way of an agreement, but the fact is that they came together to form a federation of states, meaning that they will have federal structure in the constitution. But Indiana as a state has a quasi-federal structure, meaning that both the state and the center are at par, but the center has a more higher pedestal as compared to states in general.
So under such circumstances, they have right to secede from the state if they are Union of States.
Since I've already mentioned that it is a quasi-federal structure, that means that there are also federal features in terms of the structure of the country of Indiana, meaning thereby that right to secession can also be given as part of it, considering that Article 1 specifically mentions under Clause 3 that states would also include. If your Lordship will refer to Article 1, your Lordship also states that such other territories as may be acquired by the Union. The fact that the word acquired has been mentioned, it can also be presumed to be.
You're misinterpreting things. Acquisition of a territory is something else. Here we are seeking an argument for separation.
And that is your Lordship, because the Union of Indiana had ratified an international very important convention, that is the International Covenant of Civil and Political Rights, that specifically under Article 1 states that people will be given the right to determine their political status by the virtue of the right to self-determination. Self-determination basically means that.
But Indiana people have not determined they exercise this right by adopting the constitution. Is it not the self-determination? When we say that we the people of, then meaning thereby that we have exercised the right of self-determination. Then once we have exercised the right of self-determination, country is unending.
Your Lordships, the fact is that the Constitution itself is a matter of self-determination. But the fact is that this covenant was signed considering that it also grants to Indiana other rights, considering that Article 1 specifically states that the member states will have this right to determine the polity that they want to be governed by, which helps them to develop socially and culturally in that sense. Your Lordships, if your Lordships may refer to the para 28 of the Moot proposition. The first three lines specifically mentions, since the Union of Indiana had ratified the Charter of the United Nations and the ICCPR, the Parliament of Indiana introduced the 106 Constitutional Act. meaning that it was only after the ratification that the Constitutional Amendment Act was passed and right to succession was given as a right to the states as well. Your Lordships, in this particular scenario, when we deal with the Constitutional Amendment and its validity, we have to be using the doctrine of presumption of constitutionality, which means thereby that any legislation, act, or rule that comes before your honorable bench, it has to be first presumed to be constitutional in nature, and only when it is expressly proven by the learned petitioners that it is violating the fundamental rights or part of the Constitution of Indiana, then only the court can meddle with it or interpret the court. Your Lordships, further, it is the duty of the honorable bench and your honorable court that all the provision of the particular act has to be construed in a manner so as to maintain stability and to sustain that particular provision instead of outrightly declaring it to be invalid. Your Lordships, applying this doctrine to this scenario, we can see that since only when the ICCPR was signed by the Union, that the Union came forward with a law that gave the right to secession to the states of the country. Therefore, it is in line with the aims and objectives of the ICCPR by virtue of Article 253, which states that all the international agreements have to be.
See, we have given the background of the proposition contains background of this problem. And the people of Indiana, they fought from forefront for the creation of this country for a long period, right? And after that, they have decided certain rules which is already there in preamble also. So this amendment 106, don't you think it is against the will of the framework of the Constitution?
Your Lordships, the fact.
And another thing I want to add, the councils are no one to tell the court that what is the duty and what is not the duty. You have to assist the court and you have to give efficient and ample material to the court, and then it is will be decided by the jury, by the judges.
The council please, your pardon for that. Your Lordships, the fact is that
All right, my question is, if you just go through the field of the people, framework of our Constitution, our forefathers, okay? So they have decided certain principles, which can be seen from the preamble of our Constitution. And 106 amendment, don't you think it is going to their wish and will for which they have framed this Constitution?
Your Lordships, as I already mentioned, after the passing of ICCPR, ratification by ICCPR, it came forward. But the 106 Constitutional Amendment Act is also not that easy to be passed. There has a proper rigorous procedure that has to be followed. That is, it has to first be amended by virtue of Article 368 Clause 2, wherein both the houses of the Parliament have to approve the same.
I've been throwing a question to you, though there are a lot of questions that are continuously coming to you. Before you can answer, the second question comes in. But what I would ask you is that just now you advocated that the notification was issued after complying with the procedure. Now, if a notification issued after its own, it is bound to be after complying with the procedure. But still, if it is contrary to the constitutional mandate or the basic structure of the constitution provided under the preamble, whether still it could be sustained.
Your Lordships, since in XR movement case it was held that it is not strictly unitary in nature, India as a country, it is a quasi federal structure, meaning that even both the states and the union are at par. Thus, meaning thereby that we cannot construe just the unitarianism as the basic structure of the constitution. Even the quasi federal structure as a whole has to be considered to be the basic essential structure of the constitution, as is stated in XR movement 16. It's a landmark case in this regard. Your Lordship, the best understanding.
Move further.
Yes, sir. Your Lordships, this presumption of constitutionality was also laid down in the case of N. Ramana versus New Russia, when all these provisions were mentioned. Your Lordship, thus it is pleaded that the 106 Constitutional Amendment Act is constitutional as it is in line with the aims and objectives of ICCPR and it is in line with the quasi federalism that India has given to itself. Your Lordships, with this, the Council would like to rest the case and would like to hand over the rights to my Council. It was a pleasure.
I asked my colleague that you were advocating in the first phase of an argument that uniform plays a very important role. And then uniformity in an education system also that we were permitted to put on in that. But tell me whether you are in a uniform.
Open for.
Where is it at? So how can you advocate that when you yourself you are not following it? And it's good.
Down there, Elise. Are you wearing a tie? See how helpful
Don't fight outside the point. While you were putting on your uniform.
Collectively beg to pass.
Please, please.
This is lighter moments, but to be taken care. Small things.
And you have marked for that also. Vote etiquette, I mean, haven't you?
The council again said.
Council seeks permission to approach the judge.
Tell me your proposition first, which issue you are going to be.
Your Lordship, I will be dealing with the third and the fourth issues of the instant case.
What is the third issue?
Lordship, the third issue is that the imposition of President's rule in the state of Kalosha was constitutionally valid. And the fourth issue is that the state of Kalosha can be given the right to secede from the Union of India.
So therefore, so far, what is concerned, that way you are supporting your plea.
Your Lordship, since
The right to see is there.
yes, Your Lordship, since we are representing the Union of Indiana, and Union of Indiana has passed the 106 Constitutional Amendment Act, which gives this right to secede from the Union of Indiana to the states. Therefore, Your Lordship, we are defending this right. If Your Lordship may permit, I can proceed with my permission. Warm greetings to Your Lordship. This is Council number 2 appearing on behalf of the respondents. If Your Lordship does not have any queries with the submissions of my co-counsel, the council would like to proceed with my submissions. Your Lordship, as I have already mentioned that I would be dealing with the third and the fourth issue. Your Lordship, the proceedings of my third issue, that is the imposition of President's rule in the state of Kalosha was constitutionally valid, is based on two main contentions. First, Your Lordship, that is the imposition of President's rule in the state of Kalosha was based on constitutional principles, and by imposing the emergency, the Union merely discharges constitutional duty. And secondly, Your Lordship, there was a situation of failure of constitutional machinery in the state, as required by Article 356 before imposing the President's rule. Your Lordship, before dwelling into my submissions further, I would like to just draw your attention to the language of Article 355. Your Lordship, the Article 355 says, and it imposes two duties upon the Union. First, it is the duty of the Union to protect every state from external and internal aggressions. And secondly, Your Lordship, which is the relevance here, that it is a duty of the Union that every state is carried on in accordance with the provisions of this Constitution. Therefore, Your Lordship, there is a constitutional obligation upon the Union to ensure that every state is working in accordance with the provisions of the Constitution. And whether it is a failure of constitutional machinery in the state or not is a matter of assessment which has been left upon the Union to decide. And therefore, Your Lordship, when the Union finds that there is a situation in the state where the state cannot be carried in accordance with the provisions of the Constitution, the Union can impose Article 356, Your Lordship. If Your Lordship may refer to para number 36 of the Moot proposition, Your Lordship, it is clearly mentioned that despite many efforts, the government lost majority in the state of Kalosha and the coalition government broke.
Just one question.
Yes, sir.
This Article 356 itself talk about the satisfaction of president, right? This court would like to know from you, how do you interpret this word satisfaction of president? What is this?
Much obliged, Your Lordship. Your Lordship, as the Article 356 says that the President is the supreme authority to impose Article 356. It depends upon the subjective satisfaction of the President. Your Lordship, the Council tried its best to determine the scope of the term or otherwise.
No.
In fact, I'm sorry, you are adding a word to it.
Yes, sir.
It's not a subjective satisfaction. It has to be analytically analyzed by the president.
Much obliged, Your Lordship, the Council understands the concern. Your Lordship, if you refer to the language of Article 356, it says that President either on a receipt of the report from the Governor otherwise. Your Lordship, the term otherwise was clarified by the Supreme Court in the case of Rameshwar Prasad. The Supreme Court did not delve much into it, but Your Lordship, the Supreme Court held that the term otherwise would mean the subjective satisfaction of the union. But Your Lordship, there are certain procedures and safeguards which have to be followed by the President and by the union itself before imposing Article 356.
All right, one of the articles, it clearly says there shall be a President of India with Prime Minister to aid and advise him. So, it is generally understood the satisfaction of President is the satisfaction of your cabinet. Right? So, under that backdrop,
If Your Lordship, the Council would like to repeat my question, that the Lordship is saying that the President, the will of the President depends upon the will of the Cabinet.
No, he doesn't want to say that. He says that as soon as the president comes to a conclusion that the circumstances are as such, the president rule is to be imposed, that implies that there is satisfaction of the cabinet. A decision-making process has already been taken.
Much obliged, Your Lordship, but Article 356 itself says that the imposition of President rule has to be presented within 2 months before the House of the Parliament. And if the report has been passed, only then the President rule will be continued further.
Council, that it is start, the drill start from the cabinet meeting first. Okay, please go through. And it's the latest drill. Even if the parliament is dissolved, not in session, then also it can be. It's a long.
Your Lordship, as per the limited council knowledge, there is no satisfactory judicial determination or any criteria which has to be, which would be a relevant consideration before invoking Article 356. Therefore, Your Lordship, Article 356, the question has been intrinsically left upon the union to decide whether it is a situation of failure of constitutional machinery in the state or not.
On union or on some convention established by the India as well as abroad.
Your Lordship, if we will go as per the bare language of Article 356, it depends upon the union only, Your Lordship.
No, the union word is used over here, which you are using in your address, is an abstract term. Now, in case if you want to give a subjective analysis to it, that when the Article 356 uses that it's the wisdom of the president. The wisdom of the president cannot be exclusive for the purposes of imposition of presidential. So there has to be certain root factors which are available to him to come to that conclusion. So what he wants to ask you is that, what will be the process to be adopted before the president takes a decision to impose a presidential?
Much obliged, Your Lordship. Your Lordship, even the Supreme Court itself has laid down these procedures before the president has to be satisfied before using Article 356 directly. Your Lordship, first, an alternative chance, or first, Your Lordship, a warning has to be issued to the state government to correct itself. Even if after a warning, the state government is not correcting itself, Your Lordship, then a chance has to be given to the governor to install a caretaker government for the time being. Your Lordship, even after all these circumstances fail, then Your Lordship, imposition of Article 356 would be justified. However, Your Lordship, if we refer to the reports of the Sarkaria Commission, Your Lordship, it is mentioned in point number 6, chapter number 6 of the emergency provisions of the reports of the Sarkaria Commission, that these procedures which has to be followed before imposing Article 356 can be dispensed in cases of extreme emergency, where failure on the part of the union to take immediate action will lead to disastrous consequences. Your Lordship, what the council is trying to say is that it was a case of instant emergency, Your Lordship. There was no authority the state government was already dissolved, and it got dissolved at a time when there was outraging protest in the state. Therefore, Your Lordship, the intervention of the union became not only permissible but obligatory on the part of the union, Your Lordship. If Your Lordship is satisfied, the council would like to proceed with the much obliged, Your Lordship. Your Lordship, we have referred to the case of Rameshwar Prasad versus Union of India on page number 34, para number 4 of the Moot Court Memorial. If Your Lordship may refer to it, the Supreme Court has held that the union is not expected to act as a passive spectator in cases where the state is failing to perform in accordance with the provisions of the Constitution. Your Lordship, the Council is trying to say that the Union is not expected to sit and watch the breakdown of the constitutional machinery in the state. It is expected to act promptly under such circumstances, Your Lordship.
Just one question. Whether the president rule was imposed on the failure of the state government to comply the direction of the union, or there was the resolution of the assembly by the pulling out of the coalition partner. What was the reason of imposition of the president rule? This out of these two, because one part you were saying that warning must be, you are saying referring to Article 355 and 356. But in the present case, as per the facts of the case are concerned, first there was withdrawal of the support from by the coalition partner, and thereafter the president's rule was imposed. So where the question of warning?
This court, until and unless a clear malified intentions are shown, and the burden of showing this malified intentions lies on the petitioner, Your Lordship. Your Lordship, the petitioner has misguided the bench. The petitioners contended that the president rule was imposed due to the violent protests in the state. But as Your Lordship, the council has already clarified that the president's rule was imposed after the breakdown of the coalition government, when no authority was left to look after those protests, Your Lordship.
But petitioner's case is that the union has not given an opportunity to explore the forming of the alternate government, and they have not permitted and they have not directed that the floor test should be conducted by the government.
Your Lordship, when the president rule was imposed, just before that, there were secessionist tendencies in the state of Kalosha, Your Lordship. Your Lordship, it is contended that under such circumstances, where a state is demanding secession from the union, Your Lordship, a floor test would not be possible. Your Lordship, the union government installed a caretaker government for the time being. Your Lordship, when the protest would have cooled down in the near future, the floor test would have been conducted, or a fresh elections would have been also conducted, Your Lordship.
Just argue in the light of SR movement.
SR movement.
Instead of Rajasthan or in India, both.
Much obliged, Your Lordship. Your Lordship, we have also referred to the case of SR movement.
This court has already given a wide guidelines in this case.
Much obliged, Your Lordship. The council also understands the concern. Your Lordship, it is the council accepts the fact that imposing of Article 356 under these circumstances led to a serious inroad to the principles of federalism that is practiced by the Constitution of Indiana. However, Your Lordship, this inroad is permitted by the Constitution itself, because as per Article 356, a subjective satisfaction of the president, a situation has arisen where the state government cannot be carried in accordance with the provisions of the Constitution. Your Lordship, the Supreme Court in the SR Mumbai case also held that the truth and the correctness of the material. Your Lordship, we have referred to the case of SR Mumbai in page number 35, point number 5. Yes, Your Lordship. The Supreme Court has also laid that the truth and the correctness of the material of the proclamation of emergency would not be questioned by the court until and unless a clear-cut case is shown that there has been abuse of power. Your Lordship, it is also mentioned in the SR Mumbai case judgment that the Supreme Court laid that it is not possible to limit the scope of Article 356 to any specific conditions. Therefore, Your Lordship, it is being contended that Article 356 is such an extraordinary remedy. Your Lordship, it is used in such circumstances where, Your Lordship, sometimes the situation becomes a grave emergency. The situation could have worsened, leading to loss of life and also the loss of properties, Your Lordship. Therefore, Your Lordship, the imposition of president rule in the absence of a state was justified in the instant case, Your Lordship.
So will that be taken as to be a substitute of the word satisfied used under Article 356? Maybe because there is a chaos in the state. Maybe because there is a failure or there is a religious animosity. Will that be substituting the word satisfaction used under Article 356 to bifurcate the state from the union?
Much obliged, Your Lordship. The term satisfaction has to be wide. It requires a greater level of satisfaction. However, Your Lordship, the instant case Your Lordship, there was no state to control those protests, Your Lordship. Even if we have imposed Section 144 of the CRPC, Your Lordship, the Section 144 of the CRPC also says that the DMs and the SDMs under the control of the state government, Your Lordship. Then how could a state could have performed without the authority of law, Your Lordship? Without us government, how could our state have been performed, Your Lordship? It would have led to an anarchy rather than processing rather than following a due process of law, Your Lordship.
One thing I just want to know, you know, the president does not have its own mechanism to get the material, gather material to form as opinion or satisfaction. It has to depend upon the two sources. One is report from the governor under Article 356, and secondly, otherwise, well, it can be from cabinet or the aid and advisor of cabinet of ministers and all. In the particular case, there was the government has fallen down. So otherwise may not apply. What would apply? The governor's report. Was there any governor's report to the president to come to a satisfaction and apply its mind whether the president rule has to be enforced or not? Or in the absence of governor's opinion, when there is no otherwise part satisfied, how come the prisoner rule can be imposed?
Your Lordship, as Article 356 rightly says that it has to be either from the report of the governor or otherwise, Your
So
Lordship.
therefore it says the president on its own does not have any machinery to gather information. Has this opinion of certain has to be based on the sources coming from the two streams. One is governors, other is otherwise. Otherwise, you have just explained it, that it may be on the aid and the right of ministers, the union might, but here there is no minister because the ministry has failed, the government has failed. But even if the government fails, the governor doesn't fail, the office of governor remains. And the president has to act through the governor only. So in that circumstances, whether there was any report of the governor or in the absence of report, how can the president rule can be imposed? If the otherwise part is not satisfied.
Your Lordship, the council understands the concern. Your Lordship, it is mentioned in the Moot court proposition that efforts were made by the union to restore the government in the state of Kalusia. However, Your Lordship, due to the conflicting of opinions between the parties, the state government could not be restored, Your Lordship. And Your Lordship, the term otherwise in the Article 356 cannot be restricted to some specific conditions. The scope of the term otherwise is very wide, Your Lordship. And it would depend upon the subjective satisfaction of the president, Your Lordship. Either it can also be from the reports of the cabinet minister running the union government, Your Lordship.
All right, so here what will happen? There are no governor's report.
Yes, Your Lordship, the governor's report was
Not there.
Yes.
Whether he cannot be had advice or any opinion of that, when person has advice, or produce some material.
Your Lordship, the Moot proposition is silent about this fact, Your Lordship. Whether a report from the union was obtained or not.
No, but the Moot proposition is silent. You might have taken some resolution that would have been replied.
Your Lordship, the councils have mentioned certain cases where the term otherwise has been.
It is not the question of law, it is the question of fact. When we say that there is satisfaction of the president, and you understand the president by him own cannot give any opinion, it is always he is consulted and he is advised by the council of ministers. When the council of ministers decides something, it should be on the basis of some material. There is no specific material in the Moot proposition, but you can presume that there might be some material placed before the council of ministers to arrive to a conclusion that that possibilities were explored to form a government, and it could not materialize. So this is the question. That this is the one thing is it is not the subjective satisfaction. When a satisfaction is recorded on the basis of some material, then it is always objective.
That's what. Move further.
Your Lordship, The council also understands this concern, but your lordship, the council would like to plead that the case was of a grave emergency, your lordship. If the union would have waited for the report from the cabinet ministers or a report from the governor, the situation could have worsened in the state. Your lordship.
In that eventuality, you are making the use of word satisfaction as to be a nullity in the statute books. Because otherwise cannot be a substitute for the word satisfaction.
But your lordship, the bare language of Article 356 says that the president, either on the receipt of the report from the governor or otherwise, your lordship.
That's correct. Then there is a comma.
Yes, your lordship, or otherwise.
Then or otherwise cannot override the use of word satisfaction. Because for satisfying all three prior conditions, satisfaction is the prime ingredient to impose presidency.
Yes.
And another thing I want to add is what the other judges are saying. You said that this particular state is having diversified religions. In the beginning only it was said, right? And you were aware of this thing that anything can be accelerated at any time. So there is a diversity and you said there was grave emergency. What emergency? Just tell us that. Usually these protests keep on going everywhere. So how do you correlate this emergency, diversity, religious differences as well as the report given by the cabinet? We could not wait for the report and that is why we did this and we wanted to go ahead with it. So you have to correlate the whole things.
And you are representing center, you must be having some particular knowledge.
Yeah.
Which was provided to you by the government, that these are the inputs on the basis of which the emergency was.
Pulling a question from you.
All right, just to add to your ladyship, you have used the word grave emergency. I think you are mistaken. This word has also been used by Constitution, but that is in Article 352. And when the grave emergency exists, then it has to go for national emergency, not here.
Yes, your lordship, the term has not been used as per the provisions of the constitution. It was just a general term.
Casually.
Your lordship, to indicate a situation where there was violent protest in the state and the protests were already intensified. Your lordship. Yes, your lordship.
You understand that. That
Yes.
is why, these are diluted things, very simple things.
Yes, your
It
lordship.
is not some, very great protest going on where some burnings are going and all this thing. Protest
And
is part of any
when
state's
you
life.
are supporting the judicial rule, you have to be armed with all kinds of questions that may come up, right? I don't know, there is a normal saying is, all of you are going to be a Twitter council. A council always has to think on its legs. Don't remain confined to a brief. Read something more than that.
Rather, I would add what my brother has said, that when you are arguing a matter, the presumption which we are drawing is that your client has briefed you everything for the purposes of justifying satisfaction to your notification issue, but that is not being divulged by you.
Your lordship, we have nothing against the state of Pelosia. In the next issue, we are also giving them the right to secede, provided they pass the 106 Constitutional Amendment Act test. Your leadership, as your leadership has mentioned, that a situation of law and order is different from a situation of failure of constitutional machinery in the state. But your leadership, a situation of law and order is a condition precedent that can turn into a condition of failure of constitutional machinery in the state. And your leadership, in the instant case, the situation of law and order was accompanied by a political breakdown where there was no authority.
May I have the next point?
You have one more issue.
Yes, your
Please,
the council would like to
come on,
Be quick.
1 minute.
Yes, your leadership. The council would just like to summarize the fourth issue. Your lordship, moving on to the contentions of the fourth issue, that is the state of Pelosia can be given the right to secede. Your lordship, it is mentioned on para number 28 of the Moot proposition that the Union of Indiana has ratified the ICCPR and the UN Charter. Your lordship, by virtue of Article 1 of the ICCPR, it states that all people have the right to self-determination, and by virtue of that, they are right to determine their political status. And your lordship, by virtue of Article 253 of the Constitution of Indiana, which gives the Parliament the power to pass and legislate in order to implement the international agreements, Indiana has a duty to formulate these rights into its own constitution, your lordship. Not only Article 253, but Article 51 of the Constitution also specifically mentions that.
That's one thing. Just now you argued before that, if this amendment is done, there are three ways to have a constitutional amendment.
Your Lordship, the amendment to the Constitution can be initiated in either house of the Parliament.
Not that.
It has to be passed in each house by total membership of that house and not less than 2/3 of the majority, Your Lordship. Then after getting passed by both the houses, it has to get the consent of the President. And it has to conform with the basic structure of the Constitution of India.
So those are the essentialities which are required. But the question is entirely different.
All right, we move on, because we have already time out, so come on, finally, fastly.
Yes, Your Lordship, the Constitution, which specifically mentions that the states shall respect all the provisions related to international law and shall make best efforts to fulfill its treaty obligations. Your Lordship, what the Council is trying to put forward is that now 106 Constitutional Amendment Act has been passed. It has become a law. Now the states have the constitutional right to secede, provided they pass the test of the 106 Constitutional Amendment Act itself. That is a referendum, and then it has to go through both the houses of the Parliament, Your Lordship. Your Lordship, on one hand, that any state cannot be given the right to secession so easily, Your Lordship. If Your Lordship does not have any queries with the submission, the Council would just let the case with the press. Majority, Your Lordship. In light of the issues raised, arguments advanced and the authorities cited, the Council for the respondents humbly prays before this honorable court to please adjudge, hold and declare that the notification issued by the state government of Colombia under section 133, subclause 2 of the Colombia Education Act, pertaining to ban on entry of students wearing hijab in schools and colleges as constitutional and not violative of Article 19(1)(a) and 25 of the Constitution of India. Secondly, Your Lordship, 106 Constitutional Amendment Act 2022 to be declared as constitutionally valid. Imposition of President's rule in the state of Colombia to be declared as constitutionally valid. And lastly, Your Lordship, the state of Colombia can be given the right to secede from the Union of Indiana, provided they pass the test of the 106 Constitutional Amendment Act and pass any other order that the Honorable may deem fit in the interest of justice. Thank you. It was a pleasure having you before this court.
Do you want to say something?
You opt for the liberty?
We are reading any new points, then they also have a right
Please,
to.
I have not read any new one. I will really read the argument. Lots of emphasis have been given on the point of parity and equality in the context of union law. I must contend that I am not, I do not look at far with my colleagues sitting in front of your lordship as a very tough. But this institution has still done some major in this competition. Now, because I am covering my head, can it be said that I am not wearing uniform? In my humble submission, the answer is resounding no. And the second point is, my lord, the AK Gopalan jurisprudence has been cited. That the lordships are aware that the AK Gopalan jurisprudence has been disagreed upon by lordships in subsequent benches in the bank nationalization case. And in the recent judgment, just now reported a few days back, in Kaushal Kishore versus State, the judgment rendered by the lordship P. Ramaswamy, it clearly said that while imposing restriction on Article 19, the list is very exhaustive. No other interpretation, no vague restriction under the guise of social interest or social order cannot be imposed. But the third is, they said visible expression. Now I must make your lordship and the Constituent Assembly case. My lord, there was a member in the Constituent Assembly debate representing the Jammu Hussain. My lord, he brought an amendment to the draft Article 25 that India being a secular, there should be a proviso that no visible expression of religion should be there. The amendment was rejected by the Constituent Assembly. My lords, next is right to livelihood has been invoked to justify the right to self-determination. My lord, the right to livelihood, which is provided by the Constitution, is now put against the Constitution itself. My lord, another most important is religious oppression, the reason which is applied for secession, religious oppression. if at all there is that there is religious exploitation, then I must ask myself only, then why your lordships are here? In the words of Chinnappa, the Lord Justice Chinnappa Reddy, your lordship have and is one. Now the another point is, my lord, I will just cover in 30 seconds. In this 30 seconds. My lord, they said its union is not expected to be a mute spectator. My lord, indeed, the proposition is right. Union is not expected to be a mute spectator in a case of disturbance. But my humble question to myself is, where is the disturbance? Is mere protest is a disturbance? Going by that proposition, my lord, just now Kisan Andolan happened, going by that proposition, Union of Territories are the fit case to impose President. My humble solution is that I am with go. My lord, last is, I see your lordship. Please, madam. My lord, this is how I read.
Your Lordships, regarding the solemn governance, as my government petitioners have already stated their governance, your Lordship, the first was that the wearing of turban has always been banned and it's still in purpose. The argument is that in this particular case scenario as well, we are not specifically saying that hijab is banned. In general, anything that is not in the proper course of uniform is banned. That means that even turban as a right is not been mentioned anywhere in the Constitution. And Article 25 as well, only kefan is mentioned. Meaning thereby that the word proper uniform can be also connotated to mean other things, which are except turbans or except headscarves even. Your Lordships, it is also submitted that regarding the argument about the third issue, that the union cannot be a mute spectator, it is submitted that the fact that there was a disturbance in the state of Colossia to an extent that even the government had broken down and the numbers had failed. Meaning thereby that the situation demanded that there should be immediate action and a prompt action in that regard. And that prompt action, when the government is resolved, could only be coming from this union in general, because the union, as has already been mentioned, has the right to protect the states in terms of emergencies, in terms of any disturbance that the state government is not able to cater to. So in this regard as well, since the union had the power to do so, the union took a prompt action and took the and will conduct the floor test people only when the entire situation has cooled down and the state government is restored in the state of Colossia.
So how do you want to go about it? Do we have to wait here or do we? No, I heard.
What is the